We have two cases on the docket today. The first case is RJR versus Whitmire. I'm going to expand the argument in that case to at least 20 minutes per side so you can adjust your compasses accordingly. And we'll probably take a short break after that first case. Is the appellant ready to proceed?
Yes, Your Honor.
You may.
Michael Carvin for Appellant RJR. I'd like to reserve 4 minutes for rebuttal, if I might. It's black letter law that to constitute fraud, you need to engage in misleading half statements upon which the plaintiff detrimentally relies. Under the jury instruction here, RJR was held liable for fraud even if it had never made a misleading statement to anyone, because pure silence, failure to disclose the defects in cigarettes, was sufficient to constitute fraud. Under the plaintiff's interpretation of Martin, even if the plaintiff had never heard or seen or relied on any misleading half statement by Reynolds, we could nonetheless be held liable for fraud. The first is a clear error of law with respect to the elements of fraud, and the plaintiff's interpretation of Martin is a clear error with respect to plaintiff's burden to prove the elements of fraud. Under the jury instructions, it was, did the plaintiff detrimentally rely on concealing or omitting facts that would be material, which means that we would be liable for concealing or omitting, not through silence, not disclosing it. So, as the plaintiff argued in front of the jury, and as he repeats on page 25 of his brief here, the question for the jury was, if we had disclosed these negative facts about cigarettes, would that have made a difference to Mrs. Whitmire? But it's black letter law that we don't have any obligation to disclose. We can conceal or omit facts unless we're her fiduciary, which clearly we're not in an arm's length transaction. Now, I want to emphasize that concealing or omitting facts does play into whether or not fraud occurs. If, for example, you make a statement and it's a half-truth because you've concealed or omitted something that would make the statement you made misleading. Dignan made the point about if you say the car's transmission is fine, but you know the car's transmission is going to blow up the next day, and you conceal that from the purchaser, then that's fraud. But you need to make a statement that's half-true because you've concealed or omitted facts that would make it not misleading.
Well, if I may,
Sure,
the Engel findings that I don't think you disagree with on the brief, the common liability findings, if you will, that they talk about in Douglas at length, include that your clients concealed or omitted information, right?
Correct.
I mean, isn't your argument that the plaintiff here could not and did not state any reliance on any statement or omission for that matter?
I'm making 2 points, Your Honor. The first is, it is true that they did have a conceal or omit prong in Engel. But as we point out, if you look at the jury instructions in Engels, that's because they said, did they conceal or omit facts that were necessary to make the statements not misleading? So our first point on the jury instructions is there needs to be a statement to trigger the obligation not to conceal or omit. That you will not find in these jury instructions, so they're wrong. As to your second point, Your Honor, it is true that concealing or omitting material facts was one of the Engel findings that was given res judicata effect in the Engel progeny cases. But as Douglas made clear, and I think Engel itself probably made clear, that simply established that we had engaged in bad acts, that with respect to all class members, that went to our conduct. But Douglas emphasized...
But your argument on appeal, your primary argument is that aside from the faulty jury instruction, and I see how that obviously ties into whether there could have been fraudulent misrepresentation, you're entitled to judgment as a matter of law, as the trial judge entered in Berger, because there's no evidence in this case that the plaintiff relied on any kind, even assuming there were statements, right?
That's entirely correct.
And your argument is that our holding in Martin, where we said, well, These statements and acts were pervasive, they were everywhere, and we're just going to allow an inference that the plaintiff relied on them to their detriment. Your argument is, I know you don't want to have to make this argument if you don't have to, but your argument, I think, is that's wrong now under Douglas.
It has to be wrong under Douglas, Your Honor, for this reason. Douglas, we went in and argued that this violates due process because in these Engel progeny cases, all the findings basically we are unable to contest in the plaintiff.
Well, let me ask you a question about Douglas. I don't know that I've ever done this in an oral argument, but I'm going to read from the opinion in Douglas and ask for your assistance in discussing it as well as the appellee. At page 428, which you cite, the majority says, in essence, that notwithstanding the argument by the tobacco companies was that the findings weren't specific enough. But if you go down page 428, it's 110 Southern 3rd, of course, and I now quote, in contrast, in Engel, citation, this court unanimously agreed that the nonspecific findings in favor of the plaintiff on fraud and misrepresentation and intentional infliction of emotional distress are inadequate to allow a subsequent jury to consider individual questions of reliance and legal cause, and held that these findings in the civil conspiracy misrepresentation, finding which relies on the underlying tort of misrepresentation, could not stand. Will you elaborate on that, what you think that means?
Well, I think it means two things. One is that they were making the point that they made throughout, which was all these findings did was not to show injury to the individual plaintiffs, which needed to be shown in the Engel progeny cases. Immediately following the passage you cite, they said that you need to show individual causation. In the specific context, and I believe they actually italicized this language, in the fraud context, that would mean that individual questions of reliance needed to be proved in the Engel.
Yeah, I don't see any logical way to read it any other way. In other words, in Douglas, in rejecting the constitutional challenge, the Supreme Court necessarily rejected what we held in Martin and said, like in a negligence claim, you have to prove reliance on a fraud case, a fraud claim.
Right. In any case, you need to show that we did something bad, which we'll assume the Engel finding showed we did something bad, but then the plaintiff needs to show that our bad conduct caused harm to them. In the fraud context, as you point out, that means that they relied on whatever misrepresentations or misleading statements we made.
And isn't all that Martin does is say that in that case, there was evidence from which the jury could make that inference, and we don't know what that. They don't go into a whole lot of detail about what that evidence was. They talk about, the advertising campaign, but they don't say based on that alone. I mean, for all we know, that record, including, you look at some of these federal cases that they cite, and they say, well, that there was such and such report was in the newspaper. That's a fact. The plaintiff read the newspaper every day. That's a fact. You put those together, and all of a sudden, you've got an inference. I mean, as I read your argument, you're saying that you just can't have inferences, and that's not the the law.
That's certainly not our point.
Okay.
I think there's two ways to deal with Martin. One is to say that after Douglas, it's not good law. The other is to give a savings construction to Martin along the lines that you just articulated, and that I think the panel opinion in O'Hara did, which is to say all Martin did, which it didn't purport to make new law, was say in that case there was sufficient evidence from which to infer reliance. The precise quote from Martin is, we reject the notion that there needs to be direct evidence. There can be circumstantial evidence of the sort that you just articulated. A followed B. But it didn't suggest, as the plaintiffs are now arguing, that there doesn't have to be any evidence of individual reliance, of a causal connection, that you can simply assume it based on the pervasiveness of our misstatements. And that, to me, is the key here. The other point that O'Hara made was, Martin shouldn't apply in circumstances where there's affirmative evidence that the plaintiff was uninterested in whatever tobacco company statements were pervasively made. And here we have Mr. Whitmire saying Ms. Whitmire never saw the tobacco company statements, was not influenced by them, they never discussed it. Her son affirmatively testified that she wasn't interested in these things. So unless you adopt an extreme view of Martin, which is it's simply irrelevant. You can simply assume from the activity of making misrepresentations that the plaintiff relied on it. We are entitled to a judgment as a matter of law because there's not a scintilla of evidence connecting up our statements to any actions or reliance by Mrs. Whitmire.
And go ahead, I'm sorry.
Well, that's just, I mean, that's really an argument that there may be inferences there, but the inferences that would have to be drawn just go too far, right? I mean, is that what you're saying? Because it is an inference to say there is a, pervasive advertising out there, all these things that the cases talk about, and we're going to, a jury could infer that she saw that and relied on it, but I guess your argument is that's just asking too much of the inferences.
Well, it's not really an inference, it's an assumption. In other words, if you prove that she saw a statement X and then the next day did Y, but you have to first establish the threshold that she saw it, relied on.
Well, I think what my colleague had earlier said is maybe more precisely to your point, and that is, if there's evidence in a case, for example, that the plaintiff read the Tallahassee Democrat on August the 14th, 1997, and the tobacco companies were advertising light cigarettes in 1997 in the Tallahassee newspaper market, then you would concede, I think as you have to, that if that were the evidence in the case, just like in a criminal case, the jury could infer from that she saw that advertisement.
That's fair. And again, I emphasize the word in Martin was, they characterized PM's argument in that case as saying you needed direct evidence. Well, you can prove a lot of things, including murder, through circumstantial evidence. So our argument is not that it needs to be a particular form of evidence where Mrs. Whitmire said, I relied on this to do that. But you need some threshold evidence that she was aware of, involved in, interested in our
If we agree with
representations.
you, if we agree with you, do we have to certify conflict with Dungeon?
No. In fact, they rely very heavily on that case, and I'll make 2 points. One is the holding in Duggan invalidated a jury instruction identical to this one. The jury instruction in Duggan was, did she reasonably rely to her detriment on RJR not concealing or omitting? The jury instruction here is, did she reasonably rely to her detriment on concealing or omitting? They're the same thing. In fact, of course, that's a more accurate statement. You don't rely on people to conceal stuff. You rely on them to not conceal stuff. So there's no distinction between the two. They struck down the jury instruction in it. In terms of there's some dicta I concede in Duggan, which you could argue is inconsistent with the point I was making about having to rely on statements. But there's nothing going to the Martin question. To be as clear as I can, even if Martin is 100% right, we think the jury instructions here are 100% wrong, because the key to Martin was that we were making statements that were misleading. Our complaint about the jury instructions is it has nothing to do with our statements, it has to do with our silence. But if you hold...
You're talking about the phrase or omissions?
Yes, conceal or omit material facts. In other words...
But I mean, under Engel, it's already proven that you made bad statements.
Right.
That's proven. And I just want to be clear, it's not necessarily a hostile question, but under Engel, you walk into the courtroom, the court is going to tell the jury, your clients, not personal, your clients committed bad acts, engaged in misleading advertising.
Right.
They made statements. They made statements that filter cigarettes were better. They were healthier. They were lighter. They were, somehow superior to non-filter cigarettes, et cetera.
Right.
But you have the right to put the plaintiff to the burden of persuasion to show that they saw these statements. And it can't be or omissions.
Absolutely correct. And here, there was 2 flaws in this trial. Even if she never saw any of those statements or showed any connection to those statements, and there was no evidence of that, we were nonetheless held liable. The other point I'm trying to make is, under the jury instruction, the jury didn't have to believe that she saw any statement. It was just that we should have given her information, not that she was misled by anything we said, as Martin assumed, but that if we had volunteered this information that we concealed or omitted, it would have made a difference. That's their argument in this court. That's their argument to the jury. So there's two basic flaws. You need to show that she relied on a statement. Under the Martin interpretation that they advance, you can simply assume that without proof, and that's got to be wrong, because as Douglas and Hess make clear, Engel progeny plaintiffs certainly need to prove detrimental reliance. It can't be assumed. The other point I'm making, which I acknowledge is closely related, is it's not just that there was an absence of evidence, that the jury instruction here, a reasonable jury could say, they never said anything wrong that she heard, but we're nonetheless going to hold her liable, because if they had not concealed the bad facts about cigarettes' addictiveness and health.
But just to be crystal clear, your argument is that the verdicts based on fraudulent misrepresentation and conspiracy to fraudulently misrepresent are inadequate as a matter of law, as the judge held in Berger. Therefore, that aspect of the final judgment must be vacated and the comparative faults applied to the remaining claims, or is there a requirement of a remand on that?
No.
Should we agree with you?
Yes, if you agree with us, no, then you do the comparative fault analysis, which we were unable to do because of the holding in Schiff about the intentional tort.
But there's no analysis to do. I mean, they came up with the numbers. It would just be mathematically applying it, right?
It would be 33%.
Yeah, okay. And then on the jury instruction issue, if we agreed with you as to the fraudulent concealment, I guess you would have to, it wouldn't make any difference unless we agreed with you that the conspiracy jury instructions were wrong too, and maybe you can help us with that one. You start off talking about black letter law about fraudulent concealment, but
So,
how does the conspiracy instruction?
well, obviously you can't conspire to do engage in fraud unless you properly define fraud. In other words,
But just to back up, you would agree that you'd have to prevail on the jury instruction argument as to both?
well, yes.
Okay.
Well, but let me make it clear, they're coextensive. In other words, even if they accurately define conspiracy instructions, they the jury instructions did inaccurately define what we were conspiring to do, the fraud. So they rise and fall together in that regard. Plus,
But logically, you're not arguing for a new trial. You're not arguing for a faulty jury instruction. You're arguing, based on the facts of this case, that there is no evidence of reliance by the plaintiff. I was confused by the lengthy opinion in Berger where the district judge granted judgment for the tobacco company, but also seemed to provisionally grant a new trial, but that's not your problem.
yeah, and I know we're getting a little confused here. So my prior answer went to the jury instructions, but you're right. We've got a more fundamental argument, is wholly apart from the erroneous jury instruction, we win because there was no evidence that she relied on any statement. Even if the jury instruction said, look at the statements, that would have been a proper statement of the law. But our point is there's no evidence, not a scintilla anywhere, that she relied or was aware of or influenced by any statements we made.
And you're not arguing that reliance would have to be direct. In other words, if the evidence is that she thought that the filters were helpful, she got that information from her husband. If there was evidence or a fair inference that he got it from your client, you wouldn't say that that's insufficient. I mean, I know you would say that's not a fair inference, but just to be clear, you're not saying that she would have to get that information or rely directly on a statement from.
No, it could be circuitous, but that's a very helpful point, which is the only testimony in the case. He was quite honest. He said, I engaged in this experiment about the filters and looked at the darkening, and it was my experiment, and that's why if she did have a belief that filter cigarettes were less unhealthy than unfiltered, the only evidence in the record for the basis for that belief was his experiment. He did not suggest, and there's no evidence to suggest, that he was doing this because of some misleading statement by the tobacco company. And if there had been, obviously, they would have emphasized that. And that, again, returns to my essential point, which is that absent evidence that anything we said resulted in any behavior by Mrs. Whitmire, then as a matter of law, post-Douglas, as Berger said, we are entitled to judgment as a matter of law. I'm almost out of my time, my rebuttal time, but I'm entirely happy to answer any additional questions you have.
Thank you.
Good afternoon, and may it please the court, David Sales for the appellee James Whitmire. Everything I'm about to tell the court with citations to the record is unrebutted. This is from 16-301 and was read to the jury in our expert's testimony at 1672 of the transcript. Cigarette advertising reaches virtually all Americans who can either read or understand the spoken word. Unrebutted, and there's no dispute but that this lady could read. At page 1468 of the transcript, our expert explained that it was the industry that called filtered cigarettes filters, even though they filter nothing. And the evidence was unrebutted that Mrs. Whitmire believed. She believed that when she chose a filtered cigarette, she was engaging in an act of self-preservation, just as the industry intended and wanted her to do. There was unrebutted evidence that in 1953, when Reynolds was developing, before it released the Winston cigarette, which quickly, as a result of advertising, I'll give the court the citations in a moment, became the #1 filtered cigarette in America, it had documented internally that it produced 2.5 times the number of polycyclic aromatic hydrocarbons, a cancer-causing agent known to Reynolds in the 1950s. There was unrebutted evidence at 1472, 1477-78, and 1494. The ads were the key to success of the Winston cigarette. It was marketed as a filtered cigarette. The filtered was called so effective, it quickly became the #1 cigarette. There was also evidence that we cite in our brief that it was particularly helpful, that it was particularly popular with women because women in particular were more likely to believe in the protection providing mechanisms.
Now, you said there was unrebutted evidence that Mrs. Whitmire believed that this filtered cigarettes were healthier?
There were multiple witnesses who testified to that. Her son Ronnie testified to that at trial, that she believed that she was taking precautions for her health because of the filters. There was testimony from Mr. Whitmire to that effect as well, and that's cited in our brief. But there was more. There was unrebutted testimony from our expert as well that the public believed that filters were safer in part because they are bleached white.
But that's not really relevant for fraud, is it, what the public believes?
Well, that is where we get to the line of inference. It's very important to remember really what's lurking behind this, because Reynolds has been making these same arguments for 10 years now, and none of your honors colleagues in any appellate court has accepted these arguments. We have to remember, and I think this is one of the things I'm assuming, that the court was getting at in Martin, and what the Supreme Court was getting at in Ingle. The largest share of these plaintiffs are deceased. We have some cases at the parties cite where the smokers were living at the time of trial. But the largest share of these smokers is deceased. And if the court were to embrace a rule that a statement had to be identified, contrary to every appellate court that's addressed the issue.
But isn't that what the elements of fraud are?
No, Your Honor, I disagree. Yes,
that a
go ahead, Your
statement's made and you fraudulently rely on it to your detriment?
No, and I would refer the court to the second to last paragraph of the defendant's citation to Joyner, which of course is a non-Ingle case, which is cited at 28 Southern 3rd, pages 824 to 25. It lists the number of things which are consistent, to respond to Judge Windsor's question, that are consistent with our conspiracy instruction that the trial court gave in this case, a number of things that can be adequate to support a claim of fraud. Each party to a contract must take care not to do or say anything tending to impose on the other. The concealment becomes a fraud when it is affected by misleading and deceptive talk. That's their point. Acts of conduct or silence is silence if there is any word or action on the part which tends to affirmatively to a suppression of the truth. If I'm a manufacturer of a cigarette,
the silence goes to a contractual setting. If I'm entering into a contractual relationship, which your client didn't have here with the tobacco companies, if I'm entering into a contractual relationship and I say the back 40 acres are not underwater right, and the other party doesn't say anything, that possibly could be fraud.
I disagree with that, Your Honor, because the whole reason that we're able to bring fraud claims in these cases is because there's a consumer transaction. So there are contractual relations of a type and the restatement, I think we cite these in one of our footnote, is very clear to the point.
But I mean, there's no fiduciary relationship. You concede that, right?
I agree that there's no fiduciary relationship, but I also disagree with Reynolds that they didn't ever do anything but to support the existence of a duty to disclose. I mean, if you just think about it for a moment, your honors have already addressed the issue that there's a distinction drawn between the Supreme Court between a misrepresentation claim and a concealment claim. And as we say in our brief, that necessarily means that they must be different. Misrepresentation means just that. There's necessarily the utterance of some words, an expression of something in language, which leads to a mistaken belief on the part of the person who hears it.
I mean,
in the case of
the way I think the law is that under Engel, you have the advantage of walking into court and the jury is told that the defendants, appellants here, engaged in significant, very, very bad acts. They hid information. They knew that their products caused cancer. They deliberately presented a misinformation campaign that led people to think that the Surgeon General's warnings were still debatable, that they engaged in these bad acts. That is established, even though it's proven over and over and over again in these trials, and I understand why, but that is the bad act. But for a fraudulent claim, there has to be some reliance on that behavior.
right, but
Or else the plaintiff always wins the fraudulent misrepresentation claim.
no, and I disagree with that, Your Honor. And Your Honor said something important. Your Honor said, and I understand why that evidence is reproven, but I would urge the court to consider that same question from the perspective of the people who put on the cases. Why do we put on evidence that Reynolds secretly tried to manipulate the addictiveness of nicotine? We don't do it merely if this is what Your Honor was thinking, and I don't presume to know Your Honor's thoughts, that we do it so that we can seek punitive damages. We do it because the evidence in this case, and both of our addiction experts testified to this, is overwhelming that when in 1988, for the first time, public health officials said nicotine addiction is a real thing, it's a physiologic problem, it's not a behavioral problem. Why do we put on evidence that they're trying to
Well, that goes to causation for negligence.
That goes, I
for
disagree.
Strict liability. That doesn't go to fraud until you show your client relied on it, right?
Well, that is the point, Your Honor, that I was trying to address, which is that our experts testified that when patients of theirs, people that they treat for nicotine addiction, are armed with the knowledge that was withheld from them by these defendants, they behave differently. That is the thing that changed significantly in 1988. So it's not just the issue of filters, which I've addressed significantly. Just as in Evers, there is no evidence in this record, in fact, the evidence is to the contrary, that this lady knew that nicotine was addictive. And that evidence was withheld from her at a time when the defendants were stating publicly that nicotine was not addictive. And counsel told the court that Mrs. Whitmire wasn't interested in any of these things. And I would submit to Your Honors, that may be one of the instances where, yes, some inference is justified, but the undisputed evidence is that she tried to quit repeatedly over a period of time, engaging in and participating in the so-called Great American Smokeout every year, and she couldn't do it. And one of the things that our experts said was that when patients are armed with knowledge about the reasons that they try to quit and fail, it is life-changing and life-sparing. In fact, that is why the Surgeon General's report of 1988, which described nicotine addiction as a physiologic problem and not a mere behavioral problem, was described in unrebutted testimony in this case as a watershed event. There was no evidence in this case that a number of things that this defendant and its co-conspirators withheld from the public was known to her at all, including the very important question of the fact that nicotine is addictive and the fact that they manipulate nicotine in order to try and keep smokers smoking. Imagine, if you will, the following, what Your Honor is positing to someone who's sitting from my position. We are 24 years after Engel was filed, and R.J. Reynolds Tobacco Company is arguing to an appellate court that they did not have any obligation to tell the public that nicotine was addictive.
I don't think that's what they're arguing.
I think it is what they're arguing, Your Honor.
No, I don't think that's what they're arguing. I think what they're arguing is that your client didn't rely on a statement maybe I'm missing something, but that your client could not have relied on a statement by the tobacco companies, but which did not, based on this evidence. Therefore, there can't be a jury verdict for fraudulent misrepresentation or concealment.
What about when it says?
I think that's what they're arguing.
What about when it says on every pack of filter? 'Cause there is no doubt that it was a jury question whether or not she kept smoking because she thought filters were protecting her. They're not seriously arguing that. Their lawyers at the trial court admitted that, okay? So what if we were to suggest to the court that if I buy a package of silk cigarettes and it says filter on it, what does that mean? Our expert compared the filters in a cigarette to a piece of spaghetti that's used as something called a seatbelt. They don't do anything. How can we justifiably say in a setting like this that they never made any, even if a representation were required? And by the way, I've never, in doing this for 10 years, taken the position that Martin or any other authority eliminated the requirement for proximate causation or reliance. I've never taken that position.
Or an individualized finding of reliance.
Or an individualized finding of reliance.
And that's what well, one, are you arguing that there was evidence from which the jury could conclude she relied on the word filter on the package? Is that an argument you're making?
If the defendant is entitled to argue, which they did vigorously, that she was unreasonable for not heeding the warnings, which, as we all know, very early on were quite soft, we were certainly entitled to an inference that when she read filter, she was justified in believing something. And I would just submit to the court that even that standing alone, what is a filter? A filter is something that removes something. That's what the word means. And how can we genuinely say that no representations were ever made to her? But there was more than that, because as I mentioned just a few moments ago, and the point of Martin about the pervasiveness of the advertising and the communications of the industry was that they were in fact pervasive. And that once the life story, because these cases are not just like a negligence case where you go in and you say X did Y and this happened to so-and-so. That isn't what happens. The entire life story of this lady and all of the history relating to her smoking behavior, when she started, how she started, what she heard and didn't hear, is before the jury. And this case is completely different from Berger. I have the highlighted sections of this up here. The reason you switched to light cigarettes, a living smoker, is because you like the taste of those cigarettes better. That was the evidence in the case. That evidence is completely different here. But I would submit to the court that it would be extraordinary for the court to reach a conclusion that we have to, after all of this time, when this decedent is the person who was the smoker in this case, identify, with her not being able to testify on her own behalf, a particular statement that was made by the defendant or one of its co-conspirators that resulted in what the jury ultimately found. But even if we got beyond all of that, because at some point in this litigation we have to take the parties for their word and what they argue in their briefs, and they told this court, without telling the court what was in the conspiracy construction, they told this court that with respect to the arguments they have on the issue of concealment, that there has to be something that is an act or a word or deed or whatever else is in there in that Joyner opinion. It's the second to last instruction. And I just urge the court to compare the conspiracy instruction. It was a belt and suspenders charge, I would call it. There were elements in that. I wasn't there for the charge conference that I typically oppose because I think they're redundant. Not only did the jury have to find that there was reliance upon an act, something that they say is sufficient, the jury had to find that it was difference-making, and the court said twice in both the concealment and conspiracy instruction that it had to have made a difference what was withheld from her in order for the plaintiff to prevail.
Well, didn't they say that there had to be an act to withhold information or to conceal?
An act.
I think they proposed an instruction that was similar to what.
That's right. And in the
conspiracy, there had to be a conspiracy
right.
to an act to conspire to provide
right.
that information.
And if there's no way to read the conspiracy instruction that was given in this case other than to conclude that it related to an act of concealing or omitting material facts relating to the two aspects of the Engel findings, suppression of information about the health effects of cigarettes or suppression of information about the addictiveness of nicotine.
Counsel, let me ask you a question. If you have a continuum and at one end you have a decedent who was a hermit, just didn't watch TV, didn't listen to radio, the wife bought him cigarettes and whatever was cheapest he bought. That's sort of the facts of O'Hara. Okay, the O'Hara.
The opinion certainly suggests that, I think Your Honor used the word, was not interested in.
Aloof or distant, yeah, right.
Matters,
So, the other extreme you have, and there's pervasive advertising overlaying all this, a continuum. So you have this one person who just doesn't engage in the world and just smokes cigarettes that his wife bought. Then you have the other extreme where someone's reading in the media, watching TV, reading paper, whatever. So what I'm getting at is your client seems to fall, or I should say the decedent falls closer to the O'Hara situation, because what I'm hearing is the linkage on individualized reliance is the filter. She thought the filters were better in some sense, and she got that information from somewhere. Is there anything beyond that?
There are the matters that I've been trying to discuss with the court today that include the fact that nicotine was addictive, that they knew it, and that they never. I think the disconnect between the defense position and the plaintiff's position is that the defense takes the position that if we never spoke, for example, about the addictiveness of nicotine, if the plaintiff proved that we never spoke, failed to prove that we ever spoke about that, then there could be no fraud. And that just cannot be.
Not because of reliance. I mean, those are separate issues.
Right.
There's the legal issue about whether you can satisfy the, by omitting or misrepresentation. And then there's the separate issue of reliance. And I think the question is, when we're just talking about that issue of reliance,
right,
and an individualized finding of reliance, what else is there in this case other than the filter? And I know you started off talking about experts saying that, everyone understands.
She couldn't quit, and she was denied the information that the unrebutted evidence said is necessary to quit, that nicotine is addictive.
So
that is a proximate causal relationship between a matter suppressed and the outcome in this case, based on the jury's verdict. And I would just refer to the court to Dagnan, and I want to correct counsel. The pronunciation of the case is Dagnan, D-U-I-G-N-A-N. It's my case. Counsel said that the instruction in that case was identical, and it was the basis for the reversal. That is just simply incorrect. Judge Day in that case told the jury that the issue to be resolved by the jury was whether or not the smoker relied that they would not conceal, and he negated thereby, according to the court, the causal requirement that was necessary. This is what Judge Solario said for the court, and I just urge the court to compare this to the instruction that was given on the concealment claim. An instruction requiring detrimental reliance on a misapprehension to the fact concealed or omitted will usually accurately inform the jury of what it must find with respect to the element of detrimental reliance essential to that claim. That is what we are doing here in a case where, as I mentioned previously, the Supreme Court has drawn a sharp distinction between misrepresentation.
Well, let me ask you the question I asked
Yes,
the
sir.
opposing counsel, to be fair. And that is, how do you interpret the language in Douglas, where the court said, in contrast, in Engel, I'm going to paraphrase, and I'll give you some more time. In contrast, in Engel, this court unanimously agreed that the nonspecific findings in favor of the plaintiffs on fraud and misrepresentation and intentional infliction of emotional distress are inadequate to allow a subsequent jury to consider, and they did emphasize this following phrase, individual questions of reliance and legal cause.
Right.
And we held that these findings in the civil conspiracy misrepresentation finding, which relies under the underlying tort of misrepresentation, could not stand.
I think two things. One is the point that I don't think we're arguing about. There must be something different between misrepresentation and concealment as a matter of law, because the Supreme Court told us we didn't need the Supreme Court to tell us that, but the Supreme Court did confirm that the misrepresentation claim was too generalized. Over and above that, and as we point out in our brief, this wasn't news in Douglas. Ingalls says and equates the issue of proximate cause with reliance, which is the proper framework through which that should be understood. Individual issues of causation and reliance still have to be proven. The question that we really should be debating here is not, because counsel accuses us of arguing Martin as eliminating the proximate cause requirement. If you look at the instructions that I'm defending here on appeal, they don't eliminate that. They talk specifically about reliance. And a few years ago, we were having a debate before Your Honor's colleagues about whether or not the word reliance was confusing in this setting rather than just referring to proximate cause, because in fact, it is a challenge to talk to juries about how to rely on something that was never spoken. That's why if you return to the issue of the conspiracy instruction, where Reynolds admits in its brief that tying the outcome, the difference-making conduct, to the defendant through an act, among other things, is something that is sufficient to support a verdict, and that's the instruction that we had on the conspiracy claim. On the filters, if I may.
And yes, take another 3 minutes if you like.
With respect to issues that were also unrebutted in the evidence about filters, and it is true that the expert didn't necessarily differentiate between Mrs. Whitmire and the public in general, but the unrebutted evidence was that the public believed filters were safer because they had been bleached white, and there certainly was evidence that there was an examination of the filters, and I agree that it's somewhat murky about who looked at it and who said what to whom, but that tied directly to the decedent in this case. And then the last thing I wanted to say about the filters was that there was evidence that these messages were repeated on national television. If I could just conclude with
Would
this
that be enough by itself?
Well,
inference?
I would turn the question back on the defense, because Your Honors only see, and in fairness to them, they do try to highlight some of the evidence that supported, we believe, our verdict. But what they don't do is show the way that they tried the case. Your Honors asked about the Tallahassee Democrat. This lady's not here. We can't ask her, did you see this article in the Tallahassee Democrat? But as often happens in these cases, the defendant or the plaintiff puts on the evidence of what was in the newspapers, or Reader's Digest, which was a frequent critic of the cigarette industry. They put in evidence of the Tallahassee Democrat, and maybe there was evidence that she read it periodically, maybe there wasn't, but the point being that they try to benefit from the same inferences that we try to benefit from in this litigation.
I understand that, but
fundamental. Yes, sir.
my question is, if you put on an expert who says there was pervasive misleading advertising throughout the country that many members of the public read, would that be
Inescapable is more
Okay.
more accurate.
That's okay. Would that be sufficient as a matter of law on these claims to get past a motion?
I think so, because you have to look at what the content of that information was, and some of that content is every time you buy a cigarette, it's claimed to be falsely a filter, and they don't have any way to get around that, because the unrebutted evidence in the case was this lady believed.
Well, I'm not necessarily disagreeing with you, but it seems to me a somewhat novel argument that the word filter on the pack of cigarettes is in of itself fraudulent misrepresentation per se. Every person who bought a pack of cigarettes, therefore, relied to their detriment on a fraudulent.
But I'm not saying that.
Okay.
I mean, there's a difference, most respectfully, between a legal argument and evidence. The evidence in this case is that filter, the word filter, appeared in the communications, not just the advertising. And let's not forget that the evidence also is that a cigarette package is part of the advertising. Every time it comes with the word filter. It means necessarily something. And it is for the jury, I would submit, to decide whether the repeated pervasive messaging that filters were safer, and in fact the use of the word filter itself, there was evidence in the case that that is a misleading and dishonest communication, because they don't filter anything. They were gimmicks. They were described in the defendant's own documents as gimmicks, illusions, and marketing ploys. And that is something that is unquestionably in this record. If Your Honors wanted to go that far to find something that was required, if you wanted to turn sort of a cheek away from what Martin says, and I don't think it does abandon the requirement of reliance. I think it reaffirms the requirement of reliance and just talks about how it needs to be proven. Judge Makar said in O'Hara, you know, it didn't really break any new ground, and I agree with that. We have never taken the position that we don't have to put on a reliance case. We're here arguing about what's sufficient. And our evidence was sufficient, most respectfully, and the instructions were sufficient to require the jury to conclude that it had to be difference-making what was concealed in order to justify a verdict in this case. Thank you.
Thank you, counsel.
Briefly, there was an allusion to what was undisputed in the evidence about what we did. You could have quoted Engel for all of those
Madam
things.
Clerk, will you give the appellant an additional 3 minutes, please? I think that's equal time.
I think we've come out, thank you, Your Honor. There was a lot of evidence that we made misrepresentations to the public. There's no dispute about that, and that's why it's res judicata against us in the Engel progeny cases. But Douglas, looking at exactly the same evidence that was replicated here about our pervasive misrepresentations to the public, said as clearly as a court can say, that doesn't end the case because each plaintiff needs to show individual questions of reliance, italicized. He says there's
But
no...
your opponent is arguing that concealment equates to silence, essentially, so that your silence can support a fraudulent misrepresentation, a fraudulent concealment claim. How do you respond to that?
One is Martin doesn't go near that. Martin said the jury instruction in Martin was statements, and Martin's logic was because of the pervasive statements you can infer reliance. So Martin doesn't come close to suggesting you can rely on silence. If you take that next exponential step in changing the law of fraud in Florida, what you are then saying is that any time a seller of a product doesn't say a hamburger or trans fat can cause heart disease, that he is engaged in fraud. But the law couldn't be clear in Florida under Joyner that silence alone, not representing the bad aspects of your product, can't possibly constitute fraud. So you go back to the quote that my opponent said from Joyner, if you have silence coupled with an act or talk that affirmatively suppresses the truth, then you've can argue concealment is relevant. That was also the instruction in Engel. And yes, if they had said, we said filters were unhealthy, but we concealed the fact that people compensate and draw just as much tar in through filters, then an instruction to that effect is exactly what we asked for, and that would have been okay. If they had presented some evidence that Mrs. Whitmire relied on our representations about filters, or even seen them. And
But isn't it enough that you didn't tell them about the filters?
No, that's
Well, I mean, that's a concealment, and how are they going to find out about it unless you told them?
again, because failure to disclose is not fraud in Florida. It can't be fraud because it would be preempted, because then failure to warn would be fraud. What you need is the Engel instructions made clear, is concealing a fact that renders the statement not misleading. If I say people who smoke filters get less tar, and I conceal the fact that people who smoke filters tend to compensate by drawing deeper, then those two things, the statement about them getting less tar and the suppression of the fact that they compensate, constitutes fraud. Under this jury instruction, the fact that we didn't volunteer that filtered cigarettes, like unfiltered cigarettes, are unhealthy, constitutes fraud.
But your ultimate argument is that even assuming that's correct, there's no evidence of reliance, or am I getting that wrong?
No, that's entirely right. We're making 2 points. You need to rely on a statement, but in all events, the standards, you need to rely on a statement of some kind. There needs to be a statement to trigger this, and you need to show that she saw it, heard on it. Judge Maker, actually, this is entirely indistinguishable from O'Hara in that regard. If you look at 2671, her son said that she was not interested in tobacco company advertisements or statements. He says that there's evidence that she believed filters were safer, but no one tried to connect up that belief to anything that any tobacco company said, much less the word filter. The only evidence was that her husband had done an experiment on his own and showed it to her, which led her to this belief.
You better go ahead and wrap it up.
If you collapse the notion that we have made misrepresentations with individual reliance, there is no difference between saying you can assume individual reliance and saying that individual reliance is not an element of the fraud. Then you've done precisely what Douglas said you couldn't do, and it can't be enough that you can base her injury, her reliance, simply on the basis of our misconduct.
Thank you, counsel. Court will be in a brief recess. 5 minute recess.